One sentence, that's all it takes. One missing sentence in your Florida contract can turn a normal business dispute into personal bankruptcy, even if you did nothing wrong. And I'm going to show you exactly how that happens. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. I've seen smart, hard-working business owners lose their companies, their homes, and their savings, not because of bad work, but because of one clause they didn't know was missing. By the end of this video, you'll know what that clause is and how to protect yourself before it's too late. Let me tell you about Marcus. Marcus owned a small construction company in Tampa. Good reputation, 10 employees, steady projects, solid cash flow. Everything was working. Then one day, Marcus was served with a lawsuit. A client was suing for $2 million. Now here's the part that surprises people. The lawsuit itself wasn't the real problem. Marcus had insurance. The problem was what his contract did not say. 6 months later, his business was gone, his house was gone, and Marcus filed for bankruptcy, all because of one missing clause. That clause was a limitation of liability provision. Let me show you how its absence destroyed everything. Marcus signed a subcontractor agreement with a large general contractor. The contract looked normal: payment terms, deadlines, insurance requirements. Nothing raised any red flags, but buried inside was an indemnification clause. It said Marcus would defend the general contractor in lawsuits, pay their legal fees, cover judgments if the claim involved his work. What the contract did not include: any cap, any limit, any ceiling on liability, which meant Marcus had just agreed to unlimited financial exposure. A worker was seriously injured on the job site. The worker sued everyone: the property owner, the general contractor, Marcus's company. The total claim, $3 million. Marcus assumed his insurance would protect him. Well, his policy limit was $1 million. He thought that was enough. It wasn't. The general contractor's lawyers invoked the indemnification clause. They said Marcus had to defend them, Marcus had to pay their legal fees, and Marcus had to cover their damages. Legal fees alone, $400,000. The case settled for $2.2 million. After fault allocation, Marcus's company owed $1.6 million. Insurance covered $1 million. That left $600,000 in uncovered damages, plus $400,000 in a general contractor's legal fees. That's $1 million out of pocket. Marcus didn't have it. And here's why this is especially dangerous in Florida. Florida courts enforce contracts as they're written. If the language is clear, courts will absolutely uphold broad indemnification, unlimited liability, one-sided risk, even if the deal is terrible. Florida strongly believes in freedom of contract. You signed it, you're stuck with it. Florida law doesn't care. Judges do not rescue business owners from bad agreements. If you sign it, you own it. All right, quick pause. If this is eye-opening, hit like and subscribe. This exact mistake bankrupts Florida business owners every single year. Now let me show you how Marcus could have avoided all of this. A limitation of liability clause. It does one thing. It caps your exposure, and it can limit your liability, the contract value, your insurance coverage, or another negotiated amount. Here's a simple example you can use. Notwithstanding any other provision, the total liability of contractor arising out of this agreement shall not exceed the total amount paid under this agreement. That one sentence could have saved Marcus's businesses. His contract was worth $80,000. With the liability cap, his maximum exposure would have been $80,000, not $1 million. Here's the problem. Big companies don't want you protected. They'll say, this is our standard form. Our insurance requires this. If you don't sign, we'll find someone else. But good subcontractors have leverage. At minimum, cap liability at your insurance limits. Never allow unlimited indemnification. And watch for carve-outs that destroy the cap. If the clause says it doesn't apply to indemnification, it's useless. One more thing most business owners miss. LLCs don't always protect you. Why? Because many contracts require personal guarantees. That means your LLC doesn't matter. Your personal assets are exposed and your house is back on the table. A limitation of liability clause can still cap exposure, even with a personal guarantee. That's why this clause is so critical. Marcus didn't lose everything because he was careless. He lost everything because he didn't understand the contract he signed. Contracts only matter when things go wrong, and something always goes wrong eventually. 1 hour of legal review could have saved Marcus's businesses. Don't let one missing sentence destroy everything that you've built. Like this video and subscribe for more real Florida business protection strategies, and share this with a business owner. It could save them millions of dollars. I'm Santiago Cueto, your Florida business attorney. Watch more of my videos right here.